This is the current federal tax developments for the week of August the 25th, 2025. Current federal tax developments are brought to you by your state society of CPAs, and we're going to be talking about a few things this week that have come up in taxes and one extra topic at the end. So this week, we're going to start with a federal complaint that is seeking an ERC refund, and this is an interesting one from Superior Pediatric Care versus United States, mainly because a lot of the quarters in question are based on gross receipts, and certainly the facts of the case, and we don't know what other facts were available, what was in their 941X, but it seems like a case that should have been able for the IRS to quickly resolve. So the fact that this one is dragging suggests that, yeah, they're probably still taking quite a while to get things done. And in this case, the company finally decided that the combination of both the fact that nothing had happened, the moratorium had been in place, and then with the new administration getting rid of 25% of the personnel, they just seriously said they filed this complaint, mainly because they felt if they didn't go to court right away, or didn't go to court now, they might never see their money. In essence, they may never live to see it. So we're going to kind of talk about how things go with these claims, how quickly the IRS has to act on them, which we'll discover is not good news, and the options that you have, which, especially if the claim isn't big, are not going to be great in this case. We're also going to talk about the IRS has decided to make proposed revisions to requirements related to Form 8308, which relates to partnership information reporting when there's a sale or exchange of partnership interest. That form has been problematical for a while because of requirements that certain information be reported and the timing of that when information has to go to the other parties. We will find out the IRS is going to essentially look at trying to get a more practical solution to that one at this point. A practical solution that for practical purposes they've been allowing for the last couple of years, just going to formalize that. And how about the case of Feige versus Commissioner and the interesting problem of a taxation of an unsolicited stock transfer? Is that taxable to you? Kind of interesting case. We'll take a look at a case of the question that involves, can your tax preparer who prepares a return that basically fraudulently claims refunds that you weren't aware were fraudulent in nature, can that still keep the statute open so that we're talking about a 1993 return today? And the reality is, as the Third Circuit will tell us, at least in the Third Circuit, that answer is yes. So we'll talk a little bit about the facts in Murrin. We'll also talk about some guidance the IRS has given this week, or some indirect guidance and more direct guidance related to provisions in the One Big Beautiful Bill Act. We're going to talk about some of the information that's essentially leaked out or got kind of indirectly disclosed or indirectly presented by the IRS in the draft W-2 form for 2026. Remember, they've already said they won't change the 25 ones. And it's not so much on the W-2, but as we'll discuss, one of the key factors is a discussion of a schedule for the Form 1040 that doesn't currently exist. So we'll talk a little bit about that and what that means. And that schedule leads into my final discussion, looking at the limitations of large language models for tax law issues, and not in the sense of looking at their limitations. All things have limitations. So I want to discuss both how they got consistently the same question wrong. In a way, the new IRS schedule pretty much suggests the IRS knows it doesn't work that way. I know it doesn't work that way. But unfortunately, the LLMs, and I went to three different ones, presented each one with the same query and got the same wrong response from each one. And I've had some interesting experience even going through and, kind of carrying on the conversation to see how far they would go insisting on their wrong answer. Couple of them, if I said the right words early enough, changed quickly. Gemini took a lot of work to convince that maybe it got it wrong. And it was kind of funny how I finally got it to believe it might have gotten it wrong. But we'll talk a little bit about that. So we're going to talk about that because as you'll note, I do use LLMs in my tax work. I do use them. I use LLMs. I use an LM, Notebook LM, which is not a large language model, but we'll talk about the distinction of that. in my work. But we're going to point out why they're not really something that means you don't know a thing about doing tax research or a thing about how to handle any of this, and they can take care of everything. We'll talk about, in essence, that while they're very useful tools, you have to understand what they're doing, and you also have to understand limitations that are inherent in how they're designed. So we'll talk a little bit about that. Well, let's go to the first case here, which is a lawsuit filed by Superior Pediatric Care versus United States, which is seeking basically their employee retention tax credit refund. So in this case, right, which is Superior Pediatric Care versus United States, the case has been filed in the Northern District of Texas, U.S. District Court, case number 4:25-CV-0853. Get that right. The complaint was filed on August the 10th. Now, Superior Pediatric Care filed this complaint against the USA, right, U.S. government, seeking a refund of the employee retention credit along with interest, reasonable costs, and attorney's fees related to this complaint. And the complaint asserts that its properly filed claims have simply remained unacted upon by the IRS and unpaid. And it highlights significant concerns I think a lot of taxpayers are having who have these claims in there, and tax professionals, about the processing delays for ERC claims, including some that seems like, it'd be very easy, it would seem, to quickly decide, at least for the context of most of the quarters they're talking about, whether or not they qualify. It's a simple, the gross receipts rule is a very simple test. And presumably, Mull's going to say, for the sort of work they were doing, that it seems very, very likely there was a partial suspension of their work effectively, for the first couple of quarters they applied for. Because we'll talk about what they do and why it would appear, even though they were in Texas, that they still probably, the first 2 quarters, they probably could qualify for it. Now, Superior Pediatric Care, Inc. is a for-profit corporation. It provides speech, occupational, and physical therapy services, primarily for school children in the school districts in the area covered by the Northern District of Texas. So, they're there to provide that kind of specialized care and assistance for those areas. Now, the ERC, if you don't remember, hopefully you still remember this thing, but it was established by the Coronavirus Aid, Relief, and Economic Security Act, CARES Act, that was passed on March 27, 2020. And it provided for a credit against employment taxes for eligible wages paid between March 12, 2020 and the end of that year. Initially, that credit was 50% of up to $10,000 of qualified wages annually. So essentially up to $5,000 per employee, and for $10,000 of those wages. Now, under the CARES Act, eligibility was met in one of 2 ways. Either if your activities, your operations were fully or partially suspended due to a government order, so that was the suspension order method of qualifying, or if you experienced a significant reduction in gross receipts. And for 2020, that was the gross receipts test was your gross receipts fell for the quarter in question to less than 50% of the comparable quarter in 2019. Now, that law was changed and expanded a couple of times, and the Consolidated Appropriations Act at the end of 2020 extended the ERC through June 30 of 2021 and increased the credit to 70% of up to $10,000 of qualified wages. The American Rescue Plan Act, ARPA, then later extended it through December 31st of 2021. However, we know that for the most part, in the final quarter of 21, eventually we lost the program for the vast majority of entities. So bottom line, the question is going to come here. Superior Pediatric Care is going to claim this credit, and they are claiming for all quarters that they could have qualified for. So that much would probably be one reason why it would show up on the suspicion line. But they are claiming gross receipts for the end quarters and only suspension for the first 2, which now suddenly switches it back the other way. And on the full suspension, it makes perfect sense. Those claims are way lower for the first 2 quarters because, like most small businesses, they didn't really keep many people on when everything shut down. So it makes sense that, when they were in full suspension, well, full or partial, that, they're essentially their numbers were down. So it suggests to me they probably could have qualified for gross receipts too, but we'll take a look. The plaintiff paid qualified wages and filed Form 941X, claiming refunds totaling $356,859 on or about July 3rd of 23. Now, the vast majority of those amounts were claimed in quarters that they claimed, in fact, other than the first 2 quarters, and they were claimed due to a reduction of revenue compared to the measuring period. Now, couple of facts that they recite. They did notice that, on or about September 14th of 23, the IRS announced a moratorium on all ERC claims, citing concerns about inaccurately filed claims, and that was set to last through at least the end of 23. So not very long after they put their claim in. And as we all know, we were there in 23, that their claim was clearly not really likely to be worked on before the moratorium hit. And following the moratorium on or about October 19th of 23, they announced a special withdrawal process for employers concerned about the accuracy of their claims. Now, as of the date they filed this complaint, August 10th of 2025, some ERC claims are still not being paid by the service, despite the moratorium being ended. And of course, the plaintiff here is one of those who've not received a check. They've not been told they won't receive a check. They've just not been told anything, right? Now, they noted, basically the plaintiff notes that the Biden administration stated the rate of paying claims to be slower than before the moratorium as a means to prevent fraud. But on top of that, we now have, on top of the fact they wanted to slow down, look at them in more detail, and take it slower, we now have had a major reduction in the number of employees processing claims. That's their concern, saying because of the new administration's, cutbacks in employees at the IRS. And their argument is, even though nobody said this, just automatically you've got to assume that's going to slow things down even more. And they're saying, well, we kind of have a problem right now because we would like to have this money, please, but we don't have it. Now, jurisdiction is allowed. Can they sue at this point? They filed a claim. The IRS has not answered it. The question is, yes, they can. They're bringing jurisdiction in a district court as a claim against the United States. It's brought under federal law, and it cites provisions in Title 28 of the U.S. Code, 1331, 1340, and 1346A1, but also IRC Section 7422 for refund. Now, the catch is, they noted that they timely filed claims via Form 941X within 2 years of payment, so they met the deadlines for filing a claim under 6511 and 6532. And it's likely, had they truly been late, the IRS would have by now have bounced it back to them and said, you're outside statute. They weren't. They were clearly inside statute. That was not a problem for when their claims were filed. And they said they've also met the requirement to go to district court. You can't just sue the IRS for this refund right away. You have to file a claim for refund. In this case, a Form 941X. But the rule says, and the statute of limitations for you then going to federal court, to claim, to adjudicate it there, only starts to run once the IRS has formally denied your claim. But as you may guess, the problem is nothing in the law says how quickly the IRS has to move to deny your claim. So in theory, they could sit on it forever. Does that mean you're out of luck? No. Now, that probably should have a big footnote next to it, because honestly, the old asterisk, you may not have a practical option. But in this case, $346,000 refund claim, this is practical. It's not the best option, but is a practical one to move it up because enough money's in play to justify the legal fees that will be paid to get this thing moving. You better hope you win, but that's a whole nother question. As long as more than 6 months have elapsed since the claim was filed with the IRS, and the IRS has not notified the plaintiff, they didn't notify the plaintiff that its claims were allowed, that satisfied the prerequisite for filing a refund suit. Had the IRS denied the claim, this entity did not get a denial yet. They still don't have one, unless they got one the last few days. They still don't have a denial. Then you would have 2 years from that date to go to district court. But they're saying, we're tired of waiting. We're just going to go to court now. Let's go. Let's get this settled. The advantage of that is, yeah, the timing is no longer under the control of the IRS. In essence, the district court now controls the timing. And that means that probably this refund claim is going to move to the front of the pile, because the IRS has to decide, and of course the attorneys for justice that will almost certainly be defending them in district court want to know, do we have a case? We got to develop our case. So that this almost certainly accelerated, and that may have really been the point, to accelerate IRS consideration of this claim and get it paid. Presumably that's something that occurred, and one of the things they discussed was that this could accelerate matters, because right now it's just sitting on someone's desk and nobody's doing anything. Once this gets served on the U.S. government, in essence, IRS needs to start moving to figure out if they're going to pay this or not. Now, they're seeking a judgment for refund of $356,059, interest on the overpayment under 6611, accruing from the date of the overpayment. Because, yes, IRS has to pay interest from the date of the overpayment all the way through the date paid if they don't act on the refund claim within 45 days. If they act on the refund claim within 45 days, you have to pay interest through the date you filed the claim. So, basically, that's now been blown. They're paying interest today, assuming it hasn't been paid yet. Right? They also are asking for an award for a reasonable administrative and litigation costs, including attorney's fees. That's going to take a little more work. The court's going to take a little more convincing of that, presumably. And they want a jury trial for all issues that a jury could hear. That's also somewhat helpful, I'm sure. The reason being that a jury trial raises the risk if the service wants to claim, basically it depends on how easy it is for a jury to understand why they're turning this down, assuming that they disallow any quarters. So essentially, it's got a notice to the government now that, this particular taxpayer is going to play hardball. As I note, the problem is it may not be practical for your client to play hardball. There are two reasons, and I think counsel would talk to you immediately about the two reasons. Reason number one is, it just may be that the legal fees to take the matter to court, even if we do accelerate them processing, just the fees to get to this point and to get into discovery, right, which could very well start, they're going to be, they could easily be far more than the refund. And at that point, probably it doesn't make sense, because you got to front those fees. The attorney's going to want to be paid. So you're going to have to put those fees up front. And the other reason you might not want to do it is, even if, you got a $2 million claim, if that claim is based on the partial suspension rules, and you don't have a partial suspension that clearly falls within the IRS safe harbors, we have to look at the risk. We don't have case law yet that tells us how far the courts are willing to go in saying something was a partial suspension. Do you want to be the leading party here? Because there's a risk. If it come back and say, sorry, your case doesn't count, you could have expended a lot of legal fees and have nothing to show for it. But as we said, in this case, they have decided to move forward. Most attorneys I've talked with who would do this sort of litigation have clearly said, if it's gross fees, as long as we do the preliminary work and make sure, the gross revenue numbers appear to be defensible from the ledgers, in essence, that's the one we'll litigate, because that's going to be the simplest one to prove, right? That's clear. The law is straightforward. We either are above that number, we either have dropped enough or we didn't. In this case, most quarters were drop of revenue, except for the early two. And those early two, if they are ever going to qualify for suspension, it would be those quarters, if you remember schools and the pandemic. So, hey, we got a good chance. So, for you and your stuff, if administrative remedies are inadequate or excessively delayed, you just aren't getting motion on a claim for refund. It does not have to be for ERC. It could be for anything. You file an amended return, you're asking for a tax refund, and the IRS just keeps sitting on it. Especially when we are looking at the 25% reduction in staffing, it kind of depends where that reduction is, what exactly is impacted by that reduction. Claims for refund are, like it or not, though they cost the government interest, but they're an area that the service can delay on, and they don't have any risk of losing a statute. So, it's probably tempting for the service to slow walk these now, not, devote less staff there, devote staff elsewhere. So you may face quite often the problem that you're going to be, far beyond 6 months. We'll be stretching out to a year, year and a half, 2 years, and we still don't have any action on our claim. We do have the right to pull it into district court. Have to remember the expenses, but certainly a conversation would be opened up about, does this case have enough evidence behind it? And is it for enough money that it would be worthwhile to file, basically to talk to an attorney about filing in the U.S. District Court or the Court of Claims, and just to get the process going at this point. It reminds us that basically there are huge challenges that taxpayers are going to face in getting ERC refunds because of processing backlogs, how the policy changed, etc., especially those that filed their claim for refund, well after, the years it applied to. In this case, as I said, in 23, those late filers may have quite a wait, and you need to be aware of that. We also need to have very good documentation. When you get ready to think about going to district court, your side, your client has the burden of proving their eligibility. The attorney you go and talk to will immediately want to see that. Do we have anything? If all you've got is a one-page statement that we were hurt, by ERC, that's, by these unspecified, we don't even tell which orders we're talking about, the attorney's going to probably say that we better get that stuff documented because, hey, the other problem is when we file the notice, we file in a district court, we start the clock running. If the IRS hasn't done anything, we want to make sure that we've got all our ducks in a row, so that we're ready to go. And now the IRS is the one under pressure. So really, documentation, review it carefully. We have to remember that timely filing is key. That's pretty obvious, not a problem in this case. And you got to, be able to discuss legal avenues, the pros and cons, and, is this enough money? And, should the client consider getting legal counsel from counsel that would take their case either to the district court, which is easier one probably to do, less expensive, or is this court of claim, which, by the way, that choice of venue, because you are asking for money back, you've already paid the tax, could be crucial in this case. And that's also why it's a little unnerving that we don't have really any case law. It may be nice to know how the Ninth Circuit's going to read this if I'm looking for a client here in Arizona, or would it be better to send it up to the Court of Claims so it would go to the Federal Circuit on an appeal? And right now, with the dearth of law, basically, only right now are we seeing a bunch of claims being filed, a bunch of cases being filed. And the problem is we kind of need the case law to make some judgments here. So, the attorney will probably tell you that you're kind of shooting blind to know how this is going to work out. Next up, actually some good news, proposed revisions to partnership information reporting for sales or exchanges of interest on Form 8308. Now, this is a proposed reg. It's proposed regulation 1.6050K-1, revisions to that reg. The reg project is reg-108822-25. It was published in the Federal Register on August the 19th of 2025. Now, this proposed reg is meant to modify the information reporting obligations when a partner, sells or exchanges certain partnership interests, right? The Form 8308 is provided, information gets on there, and it's going to be provided by the partnerships to both partners, right? And the problem is changes that were made recently to the law have complicated, getting that done in timely fashion. In fact, arguably, there's no way to do it in timely fashion under the current structure. So what these changes seek to basically alleviate those timing concerns, right? By, in essence, making official the dual timing that we've been using recently, right, under relief provisions. The regulations specifically address returns related to the sales, exchange, and partnership interests, where Section 751A, the hot asset rules, apply, right? This is it. And 71 exchange occurs when a transfer or a partner receives money or property in exchange for all or part of their partnership interests attributable to unrealized receivables or inventory items. Now, unrealized receivables, if you have to remember, there's a definition that makes that include a lot of things you would not call receivables, like potential 1245 recapture is an unrealized receivable. Why? Because they put a definition in of unrealized receivable that includes that. Plus, pretty much everything else could be recaptured as ordinary income. So whenever that happens, somebody sells that, the partnership has depreciable assets, there is potential 1245 recapture, especially these days when we're getting, mainly fully written off assets, right? It has, remember, bonus depreciation had been around for a number of years. Yes, we backed off of that 100% bonus for a bit here, but now we got it back again. So yeah, in a lot of cases, whenever you have it, you have, unless that equipment truly is worth less. And so the question becomes, if it's worth less, why are you still using it? It's obviously worth something. You've got this reporting, and it's a problem. Under current law, right, the current regs, it requires a partnership to file a return, typically Form 8308, and that form is titled Report of a Sale or Exchange of Certain Partnership Interests, if a Section 71A exchange occurs in a taxable year. The partnership must provide information to both partners by January 31st of the year following the exchange, and they generally use a copy of a completed Form 8308. The problem came, we added more information to the 8308. There were significant concerns about the November 30, 2020 final regulations, which added Section 1.6050K-1C2. We've had this issue for a while, right? Since the end of 2020, November of 2020. This regulation required partnerships to furnish information for Part 4 of the new Part 4 of 8308, which was information about the partnership's gain or loss from a deemed sale under 751 of the hot asset items, because that's necessary for the partners to figure out the hot asset. Because the problem was most partnerships, found this problematic as they don't have any information probably put together by the end of January. So, how can we report to you? In essence, this, for all practical purposes, meant that you really had to have the return done and this valuation done by the end of January. You had 1 month, and that simply isn't happening. So IRS had previously furnished notices 2024-19 and 2025-2 that provided limited penalty relief for partnerships that failed to provide that complete part if they provided everything else except that stuff by the January date, and by the date they basically were required to file the return on extension, they had provided the other information. We're just going to make that permanent, which always seemed to be the solution here, but the IRS never got around to doing the regulatory project. Proposed regulations are issued under the authority granted to the Secretary of Treasury primarily by 6050K subsection A, which requires returns for 71 exchanges and empowers the Secretary to prescribe information, manner, and due dates. Taxation of partnership interest, again, governed by 741, capital gain or loss, but you have the hot asset rules of 751 that essentially basically require us to first recognize ordinary income by looking inside the hot assets and then adjusting basis, and after that using the general rule of 741 to use capital gain or loss. So this reporting on this form under 6050 Cap K, that is meant to make it easier, right? To actually for the partners to be able to do this. It's information partners have to be able to report the hot asset portion of their gain. The changes, we're going to remove section of the regs 1.6050K-1C2. That will eliminate the January 31st requirement for the partnership to furnish the part for information. We're going to modify 1.6050K-1C1, replace the term completed copy of 8308, which implies you got to fill everything out, with a copy of 8308 filled out in accordance with the instructions to the form. And the revised instructions will clarify that only parts 1, 2, and 3 is required to be furnished by January 31st, or 30 days after notification. Now, this is good news, except for the minor sub-issue that they've allowed them to change the rule by changing the instructions, which again, it's much easier to do that than change the regulation. So we'll note that. The partnership will still be required to file a completed 8308, including Part 4 with its 1065. So you still got to fill everything out on 8308. Part 4 will still be there, but you don't have to do it, by January 31st for these copies that go to the other partners, as long as you complete that information later. And, and it's got Schedule K1 reporting. The information need to be furnished under 1.71-1A3, including Part 4 info, will continue to be reported on Schedule K1. So, in essence, we're going to get that information to them, but it's not going to be in the January 31st mailing. Or I should say, it doesn't have to be there. I suppose you could put it in there, but you don't need to, right? So the impact, if finalized, these will have a deregulatory effect, provide significant relief. As a practical matter, I don't see there was an option for the service to do anything but this. It's a little concerning. It took them 2 years to, finally get a project going that would relieve this, but that's okay. So the partnership gets additional time and flexibility to gather data and complete the Part 4 calculations. So we're only going to be required when we file our 8308 as part of our Form 1065, which, extended due date of that would take us through September 15th for a calendar year. Those who were involved in the transfers, the transferors, will receive comprehensive information through Schedule K1, which will be issued basically at the 1065 filing deadline. So that will align it with their tax schedule. Now, there's a little downside there, because if they had actually enforced the January date, when you're preparing an extension for your client who've sold their interest this year, and we know there's going to be a hot asset part of that sale, we would know the amount. Now we might not have good information on that. So got to keep that in mind. There is a downside to the partner filing the return. For the partner who's going to file, the sale of their interest, this is a negative. It is, basically traditional problem we have here. If the partnership gets an extension of time to provide information, and that extension takes us past the due date for the individual's return, yeah, we have to work with imperfect information. But that's not really a change from what we've seen before. These changes are considered a net benefit rather than a burden. I just think a few partners who sell their interests might complain about that, but there's not really much you can do. So it does delay the date by which information is required to be provided. So like I said, the one negative of this is April 15th arrives. You got to know how much to pay with the extension. But the partnership does not really have to furnish you information about the hot assets until September 15th. So that's it. Now, the other thing true about this, you always look at proposed regs. The IRS has made it clear you are permitted to rely on these proposed regs for 71A exchanges occurring on or after January 1st of 25 this year and before final regulations are published. In essence, we're not going to get the notices. This serves to replace the notice. And so until we get final regs, which could change and could change how this works, you can follow this. So that's going to be there. Again, I think this is pretty much what I expected to happen. I don't think there's much other option unless, they were to go back and say, well, you just literally can't extend the return. Or we don't care if you extend the return, but you got to get this done by March 15th. And that's utterly not practical either. So we just got to see. Next up, what happens when you get stock that you didn't ask for? Well, kind of. This is a case of Feige versus Commissioner with the taxation of an unsolicited stock transfer to an employee. And is that income? Okay. So the citation is Feige versus Commissioner of Internal Revenue. This is Tax Court Memo 2025-88. Came out on August the 18th. Now, this case provides some insights regarding the income inclusion of property transferred in connection with services, particularly when its receipt is disputed by the taxpayer. Okay. Now, the court focused on the applicability of IRC Section 83 and looked at the concept of a substantial risk of forfeiture and the nuanced burden of proof rules for income deficiencies and additions to tax. We got a bunch of ways they decide this. Now, where this comes from, Corey Feige, who was basically the party, the taxpayer here, she was employed by Link Energy Operations, Inc. As part of her compensation, she participated in a performance rights plan. Now, the disputed transfer, after her employment termination in November of 2014, Link transferred 100,000 shares of stock into her brokerage account on December 3rd, 2014. Now, it was her understanding, per her agreement when she, terminated employment, that these previously unvested, stock, this unvested stock would not be, hers, would not be granted to her. She was going to lose that because the company had huge financial trouble. So, they're having financial problems. And so they were basically, laying her off, is what was happening. So she believed, though, as part of her termination package, that, it had been agreed that she wouldn't get these stocks. Now, she didn't even know she had them because they went into a brokerage account on December 3, 2014. She wasn't aware of this transfer because, I'm trying to think if stock just dropped into my brokerage account, would I notice? I'd hope I would, but, I could see, especially with email notices and the like, that you just thought, oh, they're telling me about, yet another, yet another information document, about some fund I'm invested in. And, I don't really want to go read that right now. It's like, I don't really care. I'm not going to read all that. So you might miss the fact that, hey, and you probably had these stocks in your account. So you may have skimmed and missed the fact you suddenly have 100,000 shares of your former employer's stock sitting in your brokerage account. Okay. So she discovered it in January of 2015, and because she knew what she'd agreed to, she believed that was clearly erroneous. This is an error they made in December, moving these shares in. Basically, they're going to want them back. They're going to take them back. However, the shares were reported as compensation on her W-2 for the year in question, for 2014. So she's received shares. She's looking at her termination agreement, believing that, hey, this says I don't get these shares, right? So she's saying that's not my income. Okay. Now, she claims she lacked dominion or control of the shares because she said they were transferred contrary to the performance rights plan and her termination agreement, right? They're not my shares. Right. So she wanted the shares taxed under what's called treasure trove theory, right? That income inclusion should not be recognized until there is an undisputed possession. And she also said, because this would be an asset received, due to services rendered, she said, yeah, Section 83 doesn't apply, which covers that situation, because she didn't make an affirmative election under it. Now, that third point is really a misunderstanding of 83B elections. I mean, I think she viewed this as restricted stock was kind of the argument they're trying to make, that this was restricted stock and realistically, therefore, 83B would have applied. And because she didn't make an 83B election, no, she doesn't include it as income right now. Okay. Now, the court said Section 83 governs this in full, right? And 83A is what governs it. If property is transferred in connection with performance of services, its fair market values, including gross income, in the first year of the taxpayer's rights in the property are transferable or not subject to a substantial risk of forfeiture. Important to note the or there, right? Because the court's going to come back to that. Did she have the right to sell, assign, or pledge her interest to someone other than the transferor? And was the transferee would not have been required to give up the property if a risk of forfeiture materialized. So even if there was a risk of forfeiture, if she was allowed to transfer it to another party, and the company would now have no way to force that party to give them the shares back, with transferability being there, she's considered to have accession to wealth, and she's considered to have taxable income. Also, substantial risk of forfeiture, that under the regs and the case law exists only if rights are conditioned upon future performance of substantial services or a condition related to transfer's purpose where the possibility of forfeiture is substantial. Now, bottom line, remember, she has been terminated. So this clearly does not depend on future services, right? And so, I mean, our question is going to be, what's the condition here? And Section 83 governs over General Section 61 when it's inconsistent regarding time of income conclusion. That's going to be important because her treasure trove theory is a rule developed under General Section 61 gross income rules. But remember, a more specific section overrides a more general one. And so the tax court concluded that Section 63, which governs property transferred in connection with performance of services, that it determines the timing and amount of recognition, not 61, when property is transferred in exchange for services, not the 63 rules, which is where we're going to get in trouble with the treasure trove, right? Generally, the commissioner, has the, commissioner's determination, no sufficient, presumed to be correct. Taxpayer has the burdens of proof, right? Now, the court confirmed disputed shares. The disputed shares were clearly property, right? And they were transferred to her in connection for her services for her former employer, Link. And pretty much that would be conceded by both parties. That's exactly what was going on. Now, these shares were transferred after she terminated. Therefore, there were no future services expected, which is really the main way you're going to get 83B to slow up recognition. The separation agreement contained no ongoing obligations or conditions requiring the return of pay she had received. The court said there is no risk. Number one, the old rule about having to perform services and he would release it, that doesn't apply here. And the second rule, basically the separation agreement, which is what she's looking to here, it specifically does not have any provision for Link to claw back money they paid her. Right? They're saying so they have no ability to get that stock, right? So the court found that she had full ownership and control over the shares. She could have easily transferred them out of the broker's account, and said, hey, given the shares to a random person she saw on the street. She had a full right to do that, right? She could sell the shares. And the treasure trove argument, as I mentioned, was rejected because that's a Section 61 theory. The treasure trove is where you uncover something, discover something, some property that you may or may not be able to keep. There is some case law on that theory when you have a treasure trove, and we got to wait to see if you get to keep it. There was no mistake, the court decided, in Link issuing this, right? Link's energy, failure to seek recovery for months or years strongly suggested they believed the shares rightfully belonged to the taxpayer here. They believed they were her shares. I realize this fact didn't exist on December 31st of 2014, but she wasn't presenting any evidence that they actually saw it as shares they could recover. And it became more and more of a problem as the case drug out. Remember, the case now is decided in August of 2025. So, we're sitting here 11 years later, and Link has never asked for the shares back. So it suggests that they believed it was her compensation that they had to pay, right? And Section 83 is not elective. Section 83A applies without the election. 83B is what you elect. You don't elect 83. 83A governs in general if there is a restriction that will lapse with time. Then 83B comes into play, and that's when you can have an 83B election. 83B delays the normal timing of recognition of income under 83, or potentially can, but you can opt out of it, right? So the value of the 100,000 shares, which were $75,660 at the date they were transferred, was properly includable in the taxpayer's gross income for 2014. Now, like we said, the burden of proof, Commissioner bore the burden, and they followed that. Right? They bore the burden, we know, for showing that they had the burden of proof was on the taxpayer for the assessment of the taxes, but for penalties, the burden goes initially to the commissioner, right? They got to provide sufficient evidence to show the additions of tax are appropriate. Now, for failure to file penalty, the IRS showed they satisfied their burden by showing that the return was not filed on time, and she concedes she hadn't timely filed the return. Now, she argued that she was in a remote part of Alaska, right? She didn't have access to local tax professionals to resolve this. She'd always done the return by herself. Her return became complex. She was confused by the stock she didn't believe she should have gotten, and what to do about reporting that, because she had a W-2 that said it was income, but she didn't think she'd get to keep it. So she was confused, and she had some personal hardships during that period. Now, what the court says is, we understand. Yes, in the middle of nowhere in Alaska, and there's a lot of middle of nowhere in Alaska, yes, you might not be able to find a whole bunch of local EAs, CPAs, and tax attorneys that you can go talk to. However, there are other ways to communicate with them, right? And there are CPAs and tax attorneys and EAs in Alaska. I know there are at least CPAs there because I spoke to them a number of years ago, right? I gave sessions in Anchorage. So, yeah, we could have found some at least in Anchorage, if nowhere else. I realize Alaska is a huge state. That might be a long distance. But as far as communication work, as long as you have phone lines, internet, and that sort of stuff that are functional in your area, you could have communicated with a CPA in Alaska or anywhere else, or an attorney or an EA in those places. I would assume EAs and attorneys exist in Anchorage as well. You could have communicated with them. And you should have really sought them out the minute that W-2 showed up, because, you realize you had a complex situation. The fact your situation was going to be messy and complex, you figured that out the minute you opened up the W-2, right? So you should have gone after it. They're saying because of that, they saw no reasonable cause for not filing the return. How about failure to pay? The commissioner failed to meet that burden because no certified copy of a substitute for return meeting the 6020B requirements were introduced into evidence, so that penalty was thrown out. And also, same for failure to make estimated tax payments. Again, there was a failure because no evidence of her 2013 return or failure to file for 2013 was included in the record, which was necessary to determine the required annual payment. Therefore, the penalty was not sustained for payments in 2014. So those two penalties, yeah, she, unfortunately, of course, the failure to file was the biggest of them, but at least she didn't get tripped up on the other two. So, okay, we're there. So the key takeaways, this is, remember, income tax reporting for property received in exchange for services is governed by 83. If you found a Section 61 reason to exclude it, yeah, 83 determines. 83 is more specific, right? And you need to remember, if the taxpayer believes the transfer was erroneous or unsolicited, it may still be taxable. The fact that they don't know if they can keep it, they're not sure, is not really going to protect this. And it also emphasizes you don't have an excuse for not filing the return just because we don't know. We need to file something. She would have been better off had she filed a return that omitted the income, and didn't pay tax on the income, because that would have meant the failure to file penalty would at least not have been in play. But it wasn't. We're there. Section 83 is the governing issue for property transfer in connection with the service, even without any election. There you don't need to elect. 83 will apply. 83B merely applies in a limited circumstance where you can elect to accelerate inclusion. But that wasn't in play here at all. The court's strict interpretation of substantial risk of forfeitures highlights that a lack of a future service obligation or a explicit requirement to return the asset after termination will likely be seen as not having a requirement to return. In essence, the tax court is going to probably interpret that way, the way they did here. Also, remember, while the burden is on the taxpayer for the taxes, the burden goes to commissioner for penalties. Now, sometimes what the service has to show, like she just didn't file a return, that's going to be simple. Other times they have to go a bit further, so be that. And what normally happens is the IRS may meet their burden, but you will have an option to show reasonable cause for many penalties and get out of the penalty if you can carry that burden, which will be on you. And real key is it's something that everybody should understand. You want to communicate to clients, potential clients. It is their responsibility to seek professional advice if they get a complex tax situation in front of them, right? Even if you don't think you get to keep the income, you think it's wrong, that's going to be in the IRS's hands. It's very important to provide that. Every so often, you'll get a client that self-edits what they gave you. They didn't think the 1099 was taxable, so they decided not to give it to you. Yeah, you're asking your tax pro to fight with, two hands tied behind their back, right? It's really tough to battle the IRS. If I know that's going to be on the return, then we'll discuss it. We'll take a look to see if, in fact, we have a position, and we'll be able to set that up. If the first I find out about it is when we get the CP 2000 notice, it's messier. Okay, really scary case in this case, if you live in the Third Circuit, which is the case of Murrin versus Commissioner. The Third Circuit Court of Appeals decided not to follow the decision that we had in the Federal Circuit regarding what is the impact of fraudulent intent on behalf of a tax preparer when the taxpayer had no such fraudulent intent. This is a case of Murrin v. Commissioner. Okay, so this is Stephanie Murrin versus Commissioner. This is case number 24-2037. Decision was issued by the Third Circuit Court of Appeals on August the 18th. Now, this ruling was going to ask, under Section 6501C1, the IRS has the ability to assess tax at any time for a false or fraudulent return with the intent to evade tax. Does that require that the taxpayer personally was the one with the intent to evade the tax and who essentially did so in a fraudulent manner? Or does all that matter is the return was a fraudulent return and that somebody had a fraudulent intent to evade tax, very likely because, they were getting paid based on this nice big refund they promised. So we'll talk a little bit about that. The Third Circuit held, now this is consistent with how the tax court has viewed this, that the intent of a third party, such as the tax preparer, is sufficient to trigger the indefinite assessment period. Right? Now, she faced notice of deficiency issued in 2019 regarding underpayments on her tax returns from 1993 to 1999. These were over 20 years old. I know people often say, well, the IRS doesn't look back more than 6 years. They'll never notice anything back that far in the past. They obviously noticed this. Right. They went after her. Yeah, I mean, it's all well and good to have a practical answer. The IRS won't go after this. It's too far in the past. that's all well and good. It may very well normally be the case, but that's not going to be any defense if they actually do go after it. So I think you always have to tell the client they could do it. Because I know a lot of people I've talked to who have told me right off that this person has nothing to worry about. Even if she discovered that there was that fraudulent stuff back in those years, let's say you discovered because you take her over today, you see that stuff, you go, you're a total fraud back then. You got fraudulent returns. Be careful telling them don't worry about it. It's been so far in the past, the IRS will never question it. They obviously did, right? That was part of it. Now, she's arguing, and this is consistent with basically a federal circuit, I believe it's federal circuit case, or it could be DC circuit case, that had been issued years ago, that 6501C1 requires the taxpayer to have the intent to evade, right? She was unaware of the fraud, right? She didn't have fraud. She didn't know she was signing a fraudulent return, and she was not doing that with the intent to evade tax. Now, she argued that referencing the return required to be filed by the taxpayer in 6501A implies that 6501C's fraudulent intent must be limited to taxpayer. The IRS interpretation, she claims, renders the intent to evade tax superfluous, and it would offend due process. That was her attorney's argument. But the court said, okay, understand perfectly what you're saying. I understand that it's a crazy law, but here's the problem. Congress has the right to enact crazy laws. Well, they didn't say that, but I think it was the Sixth Circuit years ago that said that in one case. Congress has the right to enact ridiculous laws. And the court said the problem is we have to follow the letter of the law. The statute focuses on a false or fraudulent return with the intent to evade tax. And it has no express or implied textual indication that the intent to evade tax is confined solely to the taxpayer. There's no question if the taxpayer had that intent, they filed the return, that would be good enough. But nothing says only the taxpayer's intent is what matters here. Congress's use of the passive voice, which the taxpayer tried to claim was something that favored her position, means the statute is agnostic about who, right? Had the intent to evade tax, it focuses on the event rather than a specific actor. The problem with passive voice is, right, we're not talking about action taken. We got a passive voice. It is a fraudulent return, right? That's the key. And the preparer did it to evade tax, likely as a nice marketing technique to keep clients coming because the taxpayer was, in essence, the preparer was, creating returns that were wildly incorrect. And the court said Congress knows how to limit statutes to taxpayers' conduct. They said 6501A1 refers to the taxpayer. And the fact there is no such language in C1, it says that's deliberate choice made of Congress. Why didn't they say, where basically a fraudulent return, is filed by the taxpayer with the intent to evade tax? Why'd they leave that out here? It's not there. So the court said we have to assume that's deliberate. We're not going to write it in there for you because, I might say that's a much better statute if you wrote that in. Congress didn't, and the court does not have the right to rewrite a statute. The court said the fraud penalty provisions, 6663, 6664C1, they both explicitly reference the taxpayer's conduct. Again, Congress, knows how to limit statutes to taxpayers' conduct. Again, they're saying those other statutes suggest that talk about, the fraud penalty. They indicate that Congress, we have to assume they intentionally didn't do the same thing here for a reason. So it said, Congress treats collection of taxes differently from the penalties. The penalties require taxpayer intent, but collecting taxes that were fraudulently evaded does not. And as you might guess, the interest is going to be really, really nasty in this case. Okay. Now, they also cited two Supreme Court cases. Barton-Werfer versus Buckley in 2023. Supreme Court held that the passive voice in a bankruptcy code provision meant fraud only needed to result from someone's fraud, not necessarily the debtor's. The Third Circuit said the language in 6501C1 is essentially the same. So, Supreme Court 2023 telling the courts how to read a statute in this case, and it was a fraud issue as well, says, we need to interpret that way. And Bedarko versus Commissioner, it dictates the statute of limitations, like 6501C1, must receive a strict construction in favor of the government. Now, they distinguished precedent before. The court said Asphalt Industries versus Commissioner was misread by Murrin, right? She cited that it did not address whether a non-taxpayer could independently satisfy C1. It just addressed Asphalt Industries satisfying it. The court also openly departed from the Federal Circuit in BASR Partnership versus United States. That required taxpayer intent. Now, what they said about that one was that case predates Barton-Werfer versus Buckley, Supreme Court's decision in 2023. So first thing is the Third Circuit didn't really like the decision in the Federal Circuit, but they also said that, in any event, the Federal Circuit, if that issue comes back before them, would have to address their interpretation in light of Barton-Werfer. In essence, we have now what appears to be a split of these circuits, right, in this case. So it said, analyzing its undisputed facts, the court concluded that because Stephanie Murrin's tax preparer, Dwayne Howe, placed false misleading entries on a return with the intent to evade tax, the exception to the statute, the unlimited statute of limitation, was triggered under 6501C1. The taxpayer's intent was irrelevant. Nobody contended that Stephanie intended to evade tax. But that doesn't matter, right? The statute doesn't care whose intent. They just care somebody had it, and Dwayne Howe had it, is the court's ruling. The Third Circuit affirmed the judgment of the tax court, upholding the IRS's ability to assess tax against Stephanie outside, and I mean way outside, the standard 3-year limitation period. This is a reminder that fraudulent intent on part of the preparer or other third party can indefinitely extend the statute of limitation. And, we may have thought that BASR put this to bed a number of years ago, but the Third Circuit has brought it back to life. Obviously, the IRS argued it. Now, where they argued the Third Circuit because they believe they could carry there and they might not argue it elsewhere because they're not so sure they can carry it, that's a different issue. Because we don't see the IRS doing these 20-plus year assessments regularly, but it does mean. Now, I wouldn't be surprised if the money's there, if Murrin does, and I think the amount she's got to pay is big enough that it makes sense to finance this because, it's probably it's one of those things where it's going to be a large enough amount of interest that she's in huge financial trouble if she has to pay it. So even though it might be difficult to pay the legal fees for a Supreme Court challenge, it's way easier than taking care of this assessment. So we'll see if they try to go to the Supreme Court. The argument would be the Supreme Court should hear this case because there is a split in the circuits and finally decide which way it goes. Okay. So that's part. And while you can still challenge actual penalties and entries if they can demonstrate reasonable cause and good faith, under 664C1, the underlying tax liability is assessment at any time. So you might not be able to penalize Stephanie for any of this. She probably had good cause. She relied on a apparently, competent advisor. She had all of that background, so she won't be penalized, but she's still going to have the tax and the interest, which not great. Now, like we said, we have a split in circuits right now, and the only two circuits we've got on record are the third and the federal. Obviously, what it suggests is that what you might want to do, or at least make the IRS believe you could do, is you're going to pay the tax and then bring suit in at the Court of Claims, which would take it through the federal circuit, which would be a quick route to get the IRS ordered to issue the refund, most likely, unless the federal circuit says, Third Circuit's right. We need to consider that 2023 Supreme Court decision. Again, so it's risk. But the other choice would be, do you want to? Let's say it comes up for a client of mine here in Phoenix. Do we take it to the district court in Arizona, or does the taxpayer decide to, the taxpayer and their counsel may decide they want to go to the federal circuit, right? Tax professionals have to realize that robust due diligence is required. When they look at their return, third-party fraud is a problem. In essence, the client might want you to take a look at the prior returns. And if there's fraud there, then I think, especially in light of this case, if you're in the Third Circuit, like you're in New Jersey, they really should go talk with counsel about their exposure, because this opens up doors. So be aware of it. And every taxpayer, now this is kind of odd, because technically we should tell people, and you should always tell your clients you need to review the return, but even more so, and I don't know how the word gets out easily, but other people choosing preparers, need to understand that they need to review the return. The problem inevitably is that let's say Stephanie didn't sign, or signed the return, but simply got it from the preparer, and just simply, where do I sign? And we all know we have clients that, regardless of what you tell them, they're only going to look at the return and want to know, where do I sign? Where do I sign? And I'm sure you did it right. It's like, you never should just accept what a preparer does, because that will probably kill your, that'll kill reasonable cause. That every time has caused the courts to go back and say there's no reasonable cause for you not noticing this, because you didn't even try. Right? You got to review. We have some One Big Beautiful Bill Act issues. This is kind of interesting. A new deduction and energy credit modifications. So we'll talk a little bit about this now. We're going to have a couple things to talk here. There's a draft W-2 was issued on August 15th for 2026, not for 25, but for 26. And there was an FAQ update regarding all of the energy credits that were modified under the One Big Beautiful Bill Act, or Public Law 119-21, on August the 21st. Now, we know about the big tax changes, the One Big Beautiful Bill Act, and we've been involved with that. And, so essentially, OBBBA has substantially broadened the list of additional deductions that are used computing taxable income under Section 63, effective beginning in 2025. So let's start part of that. The new deductions, in addition to the QBI deductions, these not above the line, but you still get them if you don't itemize deductions, include now the non-itemized deduction for charitable contributions, the deduction for qualified tips, deduction for qualified overtime, deduction for car loan interest, and the additional deduction for individuals over age 65. Now, based upon information on the employee copy of the 2026 W-2, which tell people to put the information their employer gives them about their qualified tips and their qualified overtime, to report that and report that information on Schedule 1A, that posits that we're going to get a new Schedule 1A. It seems very likely that form will contain all of the, quote, Section 63 deductions that Congress has decided to fall in love with, which means 199 Cap A's line on the 1040 will likely be changed over into a line carrying a total from this new Schedule 1A, or some other schedule that 1A drops into. So look forward to that. It also means, very important, we'll discuss this on the language models, these aren't above the line deductions. They're not itemized, but like 199 Cap A, qualified business income deduction, they don't reduce AGI. And that can be important for things like, how much of a premium tax credit do you get qualified for? That can be important for IRMA, Medicare fee payments. Because yes, IRMA, especially for single individuals, kicks in at a level of tax that these things haven't even started to phase out yet. For basically, so it can kick in, or they just barely get going. Well, I think IRMA kicks in, the first phase of IRMA kicks in for a single individual at 77,000 something, or it did last year, for the 25 premium. So basically, somebody with just straight up 75,000 who could get the full 6,000 for their over 65 deduction, yeah, it still counts. And that's well below where we start qualified tips, qualified overtime, or car interest phase outs. So yeah, it's important. I say that because there is a lot of misinformation out there about these deductions, some of which appear to come from very reputable sources that regularly refer to these as above the line and even go the further step and will say that they are used in computing AGI. They're not. Absolutely not. Go to the law. You'll find every one of these is added Section 63. Go to your tax service right now. They have the code updated almost certainly. Go to Section 63 and you'll find, in addition to the 199 cap A deduction, right, the QBI, you'll find every one of these listed there because that's where you deduct them. They didn't modify Section 62, which is where you put adjustments to income, is in 62. Yeah, that go into computing AGI. It may be crucial to understand where that goes. Okay. Now, this draft W-2 is finalized. The 25 W-2 is finalized without these changes. There will be some sort of reporting, and pair reporting obligations are absolutely required in 26, and there are going to be new boxes. A new box 14B will be added to Form W-2, and we're going to get something called the Treasury Tipped Occupation Code. Remember, the IRS is supposed to release a list of occupations that traditionally receive tips prior to 2020, the end of 24. Yeah, what we know now is each one of those occupations will have a code, and the employer will be required to put that code on the Form W-2 in 26. I suspect they'll be required to separately disclose it to the employee for 25. So keep your eye on that. We have new codes in box 12 that tell us numbers our payroll systems will need to accumulate and put on the return. We will have a new box 12 code. The first one is TA. If you set up a Trump account program, right, where the employer can make contributions to an employee or the employee's dependent Trump account, which will first be able to do that on January 4th next year, well, that employer contribution to a Trump account needs to be in box 12, with code TA is the new code for that. Code TP is the amount of qualified tips. Your clients who are employers must separately account for what are qualified tips, which may not be what are taxable tips reported on the W-2. They may be different. And the likely issue is that some of the taxable tips will not be qualified tips. So that is, the way the rules work, we'll see what we get there. Similarly, you got to get qualified overtime compensation. That's not something we were used to putting anywhere on the payroll reports. But we have to now track that compensation. Remember, is just the extra amount paid, and only the extra required by the Federal Fair Labor Standards Act, federal law, not something required by state law, union agreement. The fact that we have maybe the employer just pays extra, people work on a holiday. None of that will count. We'll have to track this special overtime compensation. If you are in California, you know that they have very detailed overtime rules that require paying overtime in a lot more cases than federal law would. And so what your payroll people are probably tracking is California overtime. They're going to have to separately calculate what the federal required overtime would have been, right? Because they're almost basically, you got to pay the higher of the federal or the California overtime. California overtime will normally be higher, so that'll get you employment law done. But if you pay California overtime, then you got to go back and determine how much of the California overtime would have qualified as federal overtime. Yeah, that's it. So, and it will have Schedule 1A. How we know that's coming is it's referenced in the instructions for Box 14B and Box 12 codes TP and TT. So basically, these deductions will go on Schedule 1A. And why that suggests something new is because Schedule 1 already has parts that put items that go, up to the total income line, including AGI, right? Those other items, they're listed on that part of the form. The items that are adjustments to income are listed in Part 2 of the form, If they were going in computation of AGI, they would put them on Schedule 1. They're not. Look, read the law. And don't ask AI. We'll get to that in just a second, but don't ask an LLM. We'll get to why LLMs will struggle with answering that question. Well, they won't struggle. They'll very confidently give you the wrong answer, but they won't be hallucinating, which is what's weird. We'll get to why that's true. Also, we have a new FAQ for the accelerated termination of energy credits and deductions. Very important, especially if you're trying to get the cars now, because, September 30 is our deadline, right? Again, significantly accelerated termination date for energy credits. There's a series of questions here to go through. Clean energy credits will not be allowed for any vehicle acquired after September 30 of 2025, but there are rules in there that may mean you don't have to actually have the car in front of you on that date. We'll talk about the definition of acquired. There are ways to basically to have the purchase locked down before that date, even if you don't get the car until later. You will get the credit when you get the car. Right? That'll be true. So conceivably, with the way the FAQ is written, it would appear that's always true, even if you can't get the car delivered until January of next year. Whatever you want is back ordered. That seems less of a problem with electric vehicles recently, but it could still be a problem. If you really had one that was popular that you wanted and you couldn't get what you want, and it met the requirements, then yeah, could be next year. So if your client is looking at buying the electric vehicles, and that's whether the new, the used, or the commercial, make sure they check out this FAQ and do it quickly because obviously clock's running. Right, so energy credit deductions. They'll not be allowed for property placed in service after the end of this year. It's true for clean energy credits, right? That's property placed in service for energy efficient home improvements, and the clean energy is not any expenditures made after the end of this year. So it's not good enough to just get your contract signed in those, right? We need to have it placed in service, or we need to make the expenditures. So check those out for either one of those options. They get cut off. For various other commercial credits, they have there, they remind you about the deadlines for those. For the alternative fuel vehicle refueling property credit, June 30. Same thing for the new energy efficient home credit, construction, qualified homes acquired after June 30, and 179D, energy efficient commercial building deduction. Again, not allowed for property for construction beginning after June 30 of next year. Now, as they note, these facts are not binding on the IRS, but if you reasonably rely on these FAQs, you will not be subject to most penalties, such as negligence and accuracy penalties, if the if the court were to determine that, oh, sorry, that purchase doesn't count, because we've now ruled that purchases don't count. You had to actually have it. Don't know why the court ruled that way, but if they did, you would still be able to get out of the penalties by having relied upon the FAQ. Also, the modification defining acquired for clean energy credits. These are acquired as of the date a written binding contracts are into and a payment's been made. It's not enough to sign the contract. You've got to make a payment. It could be a nominal down payment. It could be a trade-in, but some payment must be made before September 30. So make sure your client understands that. It's not just go down to the Tesla dealer, not Tesla itself, don't really have dealers there, and just sign a contract. You got to put money down, right? Deposits have to go down. If you do that, then that is considered to be the date the vehicle was acquired. Last year when I bought my car, and yes, it was back ordered, right? I was getting one that was coming to the dealer, right? Yeah, but I signed the contract, and I put my money down, basically at that point, because you didn't do that, you weren't going to get the car, because somebody who was willing to do that would get the car when it was delivered. You could risk nobody doing that in the interim and hope the car was there and you got called first when it showed up. Considered a bad move at the time, especially for the type of car it's buying. It was a really bad move at the time. So, but that you got to do something similar. It doesn't have to be the whole payment, but you got to put at least $100, $200 down. Okay. Acquisition alone is insufficient. You're going to get it, but it doesn't entitle you to a credit unless you meet all the other requirements and you're binding. You got a binding agreement to keep that vehicle at that point. It also must be placed in service for the respective credit to be claimed. But remember, this is going to consider acquired by September 30, as long as you will get the credit in the year in which the vehicle ends up being placed in service. Okay. So that's fine. As said, if you satisfy the acquisition requirement, you will still be entitled to claim the credit when they place the vehicle in service, even if that occurs after September 30. Clean election transfer timing. Election transfer of vehicle cannot be made at the time of acquisition alone. You're advised to wait until the time of sale when you take possession to make the election. Okay. Also, energy credit online portal changes. New user registration for the Clean Vehicle Credit Program will close on September 30. The portal will remain accessible beyond this date for limited usage by previously registered users, specifically for submitting time of sale reports and updates. Okay. And now, also the Section 25C. Remember, we were going to have that thing where this year you'd get a manufacturer code that'd be reported so that your client could claim the energy efficient property addition to their home credit. Well, we're going to change that now. You're no longer required to make periodic written reports to the IRS concerning specified property, but they still must register for the credit to be recognized this year. So we're still going to have the clients and apparently still have the codes, right? For the residential clean energy credit, the credit cannot be claimed for property installed or constructed after December 31st, 2025, even if payment was made on or before that date. For installation, expenditure is treated as made when the original installation is completed. For construction or reconstruction, expenditure is treated as made when the taxpayer's use of the structure begins. So those are key if you have that residential clean energy credit. You got to get everything together. Basically, in essence, things can't drag into 26. Got to make sure you get it. We have some changes in the IRS's mailing addresses you probably should be aware of. This was pointed out by an email that was issued by Spidell. And it's really important to, recognize this, because what they recognized was there was a change that you're going to find in IRS publication 3891 that is labeled, your addresses for 2026 or for 2026, but it affects 2025 returns. And the real catch, I think, for most of us is going to be it affects 25 estimates and Form 941s for 25. And this is a mid-year loss of the Cincinnati mailing address. So you may discover that some of your clients have instructions that tell them to mail a voucher to Cincinnati if they are paying with paper. That could be a problem. And especially if your practice is primarily with clients in a state that has that problem. Ohio, I know, has it. Because, obviously they were previously sending payments to Cincinnati, if there are payments due and they wanted to pay by check, they need to now be sending them elsewhere, right? Charlotte, North Carolina. So we're going to get that, right? So these forms are submitted with payments, particularly the 1040ES and 941s are the ones that are the major problems, because most of the others we're going to file in 26. But Spidell confirmed with the IRS, these forms you're talking about are going to be filed in 25. Did you really change the address mid-year in 25? The answer is yes. Okay. These addresses are applicable to 2025 filings and payments, even though it says lockbox addresses for 2026 and estimated tax payments. Many taxpayers that were previously directed to Payment Cincinnati will have to reroute these payments to new lockbox address. I'll get that out. I believe we will take a look. So it's not that everybody who's now going to Charlotte was originally told not to go there. It means that now a lot more people are going to send stuff to Charlotte, right? Publication 3891 clarifies all individual returns of payments, all business returns of payments must be directed to a lockbox site if you're mailing in the payment. Your clients can skip all of this by using the electronic payment options with the returns, by simply having, either directly pulled out of their account with the return itself, you put the money information in, or going to the IRS website and just paying electronically online. Now for 1040ES, a number of states that previously went to Cincinnati, including Alaska, California, Ohio, Oregon, Pennsylvania, Washington, Wyoming, have to send their payments to Charlotte now. Other states, Arkansas and New York, continue to use the Louisville, Kentucky address, and filer in foreign countries or with APO, FPO addresses will also use Charlotte. Okay, latter parts are not really, things that are changing. But previously we had Cincinnati in the mix. The Cincinnati filers are now going to send their stuff to Charlotte. Okay. For 941s, employers in states such as Connecticut, Delaware, Georgia, Illinois, Kentucky, Maryland, Michigan, New York, Ohio, Pennsylvania, Tennessee, and Wisconsin have to send payments to Louisville for 941s. I know. And a bunch of other states, including Arizona, were already sending payments to Louisville. They'll continue to send there. The big danger is to verify if you have any clients that are impacted by this, because if they just use the envelopes you previously provided to them, let's say, or even if you didn't give the envelopes, the instructions that gave an address, we're going to have a little problem here, right? There are some other frequently filed forms that revised addresses for filing 25 returns, but again, we have time for this. 1040 and 1040 SR, we're going to see changes to Charlotte, North Carolina, or Louisville, Kentucky is where those will go, depending upon the state or filer. Extension of time to file, 4868, will go to Charlotte or Louisville, depending on the state. And the 940, 943, 944, 945, 1041 ES, and 2290 forms will all be directed to Louisville, right? Now, the IRS has indicated to Spidell that they will forward any returns and payments inadvertently mailed to the wrong address, right? So they will do that, and there should be no late filing or late payment penalties. So in theory, your client shouldn't notice, but we know how things are going with the IRS right now. And so there's obvious concern that clients might. It's going to be really, really important that clients contact the IRS customer service or tax practitioner hotline for abatement. But you need proof of timely payment. And remember, if they're mailing this stuff in, the only proof that's going to work is certified mail. Certified, registered, or the allowed private delivery service. So you might want to contact your clients that are paying, that want to mail in that check in September, and in essence, to change their address and make doubly sure they use certified mail. Remind them that that's important to send it certified mail. Keep the white receipt, right? I know the green card they think is the thing they need. No, we need the white receipt, because the green card could get lost in the mail, either because it never gets delivered, because that's kind of what we're protecting against, or it just gets lost coming back. So the white piece of paper is really what you need, stamped by the Postal Service employee. Yes, it does have to be a Postal Service employee, so don't go to some mailboxes, etc., or UPS store. That's what we call them these days. Yeah, those don't count. So you want to verify your tax software has the correct address. Make sure your tax software is not turning out 1040s right now, or 1040 ES is telling people to mail to the wrong address, right? Make sure your 941s, if you're doing payroll tax reports, that any 941 instructions you're giving don't show the wrong address. Make sure they're going to where it should be. You may need to manually override outdated addresses, and you might want to consider communicating these to the basically overall. Now, there is a broader issue. Obviously, electronic payments get around this. So, go to irs.gov, look for ePay. State tax consideration. Remember, none of this affects states. Do not send them to the federal. The feds tell them this too, because people will send it the wrong place, and that will be a late payment. If you send your Arizona tax payment to the IRS, it's going to probably get returned. And by the time you get a payment made to Arizona, you'll be late. So, whatever your state is, just kind of be aware. Don't mix those up. Now, what Spidell found interesting, and so do I, all of this is happening while in theory we are under the Executive Order 14247 to mandatorily switch to electronic tax payments by September 30. Why in the world is the IRS at the last minute changing where estimated tax payments go and payments with 1040s go, when supposedly, by the end of the month of September, we're supposed to be not doing that at all anymore? We haven't heard anything about how that program's going. We haven't heard anything about, are they going to make an exception for the 25, for the 25 estimates or extended 24 return payments, right? We don't know that. But as of August 22nd, no specific guidance has been released regarding this payment mandate. And that's also an issue. But as Spidell said, why change this stuff if we're just going to go electric 2 weeks, you're going to go electronic 2 weeks later? We don't have any answer in this document. We just know it's what's there. Okay, I'm going to talk about one other thing today. And I'm not talking about it. This is an article I wrote on my personal blog. And I wrote it because we ran into an issue with using LLMs, large language models, and artificial intelligence, large language models, and their use in tax law. And it was triggered by a statement made by a former Google executive that I'll discuss here in just a second, that suggested that nobody should be studying the law or medicine today because AI will totally replace those professions in the near future. Since tax practice is the law, we're dealing with the law, is he right? Or is he actually just doesn't understand what tax practitioners, what attorneys, what doctors do? And while memorization, quote unquote, large body of data is clearly an issue, and LLMs have some big advantages in dealing with large bodies of data, merely knowing all the data doesn't mean you know how to practice law, medicine, or how to do tax work or tax research. So let's talk about that. So my blog's entitled "Sometimes Memorization Just Ain't Enough," with apologies to Patti Smith, borrowing her title. Remember the song with Don Henley, right? Yes, so we're going to say sometimes memorization just ain't enough. I wrote this on August 22nd. It's on my website, edzollarscpa.com. I post things there. I mean, it's very hit and miss and not regular, but I do post there. But I thought this really isn't a tax update, but it is tax adjacent. So I thought I'd talk about it here. And we're at the end. Now, if you want tax updates, we have no more updates coming. So, if you want to kind of tune out here, you're fine. But I will tell you that I think this is important information because there is something I have noticed specifically about the One Big Beautiful Bill Act and how every large language model I have asked this question to has gotten the answer wrong in exactly the same way. Which interestingly means it's not a hallucination, because hallucinations are random things they generate when they just don't have any data. Right? They'll create private letter rulings out of thin air. ChatGPT, at least the 4.0 version, was very much, I never believed a chief counsel advice number they ever gave me, because at least 3/4 of them didn't exist, right? It loved to generate chief counsel advices. I'm not sure why those in particular, but it really did love to generate them. Haven't seen it with ChatGPT 5 yet, but haven't really pushed that hard where I'd expect to see one. Okay. They are there. So let's talk about this. Now, this is Jad Tarifi, who was founder of Google's first generative AI team. He left Google in 2001, founded his own startup that is in AI. Now, he suggests careers in law and medicine, are doomed because they are almost solely involved memorization of huge amounts of facts. And so the obvious implication is AI in its current status is able to essentially, with its vast array of knowledge, you may have heard Sam Altman will talk about how it has a PhD level of knowledge, which again, he's referring to this, what Jad calls memorization, right? That means essentially, and then the implication is, well, we don't really need PhDs anymore. And that implication is wrong. Now, when Sam says it, he doesn't ever say we don't need PhDs, but he leaves the implication here. Jad in this case was quoted as saying literally, don't study law, don't study medicine. Those professions are doomed. Okay. I think the problem here is there is a misconception about how exactly true, and I'm going to limit it to tax law analysis, is done, and the proper way to do it, and why, in fact, having all of the data in front of you doesn't mean you can get the right answer. If you don't know which data you should be paying attention to and which data you ignore, right? The problem we have here is the large language models all, and I'm talking about ChatGPT, Gemini, right? Blue Jay, which is a commercial product for tax, and Perplexity, which is, it's weird saying what Perplexity is, but you probably have heard of Perplexity. All four of them gave the same wrong answer. All four of them, when asked to list out deductions added by the basically the one big beautiful bill that are deductible above the line in computing AGI, that'd be available to somebody who has just had wage income with no business or rentals or royalties. Which of the new deductions would be available to that person, right? And no partnerships that have any of those things. Every one of them identified as such deductions. The deduction for, the deductions for qualified tips, qualified overtime, the car loan interest, and the over 65 deduction for seniors. Although, well, I guess ChatGPT kind of caught the last one as not being. But the others, all the others were in all of these. None of them reduce AGI. Absolutely none. The reason why? They were all put into the law the same way the qualified business income deduction was. And the deduction for non-itemizers for charitable contributions, which again, we brought back this year. It's there too. It's below the line. They're deductions you take only in computing taxable income, but not AGI. So you don't need to itemize to get them, but they will not reduce your AGI. And that's very important because AGI determines things like as I mentioned earlier, like what was your premium tax credit? Depends heavily on AGI and how much you need to pay back. How much you need to pay for Medicare if you're 65 or over. The IRMA calculation, their modified AGI, would change if these things were used in computing AGI because there was no change in IRMA that would have added any of these back, because it turns out they don't have to add them back because it's not there to begin with. So people could make some rather big and costly financial mistakes, at least regarding those two areas. And obviously anything that depends on AGI, whether it's tax related or not, conceivably could be impacted by this. So why they all get it wrong? Because they all did consistently. I've asked multiple ways. I checked this morning again, and they were still getting it wrong. I could rephrase it in such a way that got ChatGPT into what was a crisis for it, because it gave me an answer that just started one way, went another, and circled around, and did eventually, the last half of the answer, like the last 5 lines got the right answer, but the first 5 lines had the wrong answer. So it was kind of funny watching that one. Okay. LLMs consistently provided erroneous responses when queried about the provisions that were designed to reduce adjusted gross income. Again, I told you about all the provisions, none of them. There was no change made to Section 62, which is important because that's where we put changes. We add brand new out of the blue deductions that aren't captured as business deductions, right? Or 212 deductions if it's going to be a rental or royalty. That's where we put things that we use in computing AGI. Like the $300 deduction for teachers, classroom expenses, that was added to Section 62 when it came into law, right? Deductions for alimony were at that point. We still have it. You got the old enough alimony agreement. That's in there, right? They're in Section 62, specifically addressed. No changes were made to Section 62 by any of those provisions. They do not reduce AGI. So, so basically, because I authored the article, so I'm the author. I used Notebook LM. I do use AI. See, I use Notebook LM to help me put slides together here to summarize my article. Which was not written with the assistance of AI. Except for proofing. I do use AI for summarizing quite a bit. See it in the articles every time because it's very good at that, or at least Notebook LM is. And I will help explain why I use Notebook LM far more than I use LLMs. But I do use LLMs, so they're still there, right? So the problem is, despite the fact that, as Jad noted, these models knew the entire Internal Revenue Code as it existed last year. They're in their models. They then went to the web and got update information, so they knew what the One Big Beautiful Bill Act text had changed. So why? Why did they answer the question wrong? And not just one of them, all of them. They all got the same wrong answer. Identical. Because what they're doing is not what you have to do to analyze law. This is the problem. Rote memorization has never been and never will be the sole method for ascertaining legal principles and their application to tax law. Large language models rely on on what's kind of, it's a big database, but let's go ahead and let's use, the term, that was put, we're just going to call it memorization. They absolutely know, in the sense they can know, but they do absolutely have instantly at their fingertips, instantly accessible, the entire Internal Revenue Code, and because they now go to the web to update themselves, they have the entire text of the law change. They have every tax article ever written that they were allowed to add. It's like every article that's ever been put on the web for tax advisor is in there. All the law firm write-ups of these laws are in their database. The write-ups that were posted by Kiplinger and CNBC, etc., they're in their database, right? All of the regulations, the court cases, the IRS private letter rulings, chief counsel advices, right? Instruction books from every year that were put up on the web. All of that, they, quote, know. And they draw on that to, answer queries. They had everything they needed to get the right answer. So why didn't they? Because the problem was they had way more than they needed. And some of those way more items had wrong information. And quite a bit of them did. We will discuss kind of what this is. But what they should have done was read the law, figured out, exactly, when I look at the new bill, which IRC existing sections were changed, what exactly did they change, right? Okay. Update the code to roll that forward to what we have now, to make those changes. And then looking at the code, follow through the cross-references and make sure anything that's cross-referenced, if that was updated by another provision in the bill, make sure you do that update. And then you read the code, right? Tracing references is extremely important. You will find out right here is where every one of the LLMs went wrong, because none of them do any of that. I shouldn't say the LLMs don't. We will get to one that did. Okay? But none of them do that. Right? They didn't go there. Then, once you've taken a look at what the law says, you take a look at each provision that was added for this deduction, and you have to determine, is each phrase ambiguous or unambiguous? What I mean by that, is there only one possible way to read each section of this statute that gives us a deduction, or is it subject to interpretation? And that's important because, as the Supreme Court said, you've heard me mention the Germain case many times. As Justice Thomas says, our analysis begins with the code. And if the answer of how the code reads is unambiguous, our analysis ends with the code. We don't care what anything else says. I mean, unless it's unconstitutional. So presuming we don't have a constitution problem, which we should not have any with these, then we look first at the code, and only if the code does not provide a clear answer do we go look at anything else. Right? And then we do our interpretation of the code based on the standard canons of statutory construction. That's the Loper-Bright theory. But you got to start with the code alone. And the code's going to be the code that existed before the bill, and then the changes the bills say to make. The way the Congress writes laws, you have to go, everything just tells you what to change in the existing code. Or are provisions that won't be in the code, but you have to consider, right, the uncodified stuff. The problem was the LLMs had way more material to look at. And that material, the sheer volume of it, and a consistent thing they kept finding that led them to make a bad inference about how the tax law works, meant they all got it wrong and said each one of those is used in computing AGI. And I suspect at least a few of you right now are saying, well, I read here that all those are in AGI. You're wrong. No, I'm not wrong. This one I will absolutely go on. I'm not wrong. Because most full legal analysis I've seen from every attorney, and I've triple checked this because I saw that. I know where the change, I know where this goes. I know where the cross-reference is. I know what the cross-reference means. Section 63, sticking something in there, you do that because you're going to get the QBI style treatment. You set it in 62 if you want to get the treatment for something like the educators above the line deduction. Classroom teachers, I should say. Get that right. Okay. Now, if it's not clear, you would then go to other binding guidance, right? We take this in order. We look for a binding court case, regulations, right? Regulations, court cases, various other things that are there that are binding, revenue rulings, etc., lesser extent binding. And we would then evaluate all of that, as we're told in Regulation 1.6662-4D. But again, that's restricted. We do not look at editorial commentary at this point. That is anything written by somebody other than the IRS or the courts. Right? And even with the IRS and the courts, we know there's a hierarchy of what of those things are more significant and what are less. There's a hierarchy that we follow. Again, the LLMs have no such boundary. Right? If in fact, we're going to go those, we took our guidance, we take a look at where the laws changed since the guidance was issued, how high the guidance rates, and if that also doesn't yet fully, get us in line as to what this means, then we might look at expert discussions from third-party sources and non-binding official guidance. And even then, we're going to edit down to what we look at. We're not going to look at everything. Somebody who has no experience in tax whatsoever that posts an hour-long diatribe on YouTube, telling us, how these deductions work is not something we're going to pay any attention to. Right? Okay. Now, the LLMs are better at catching that last group. Right. They actually do have ways of doing it just like search engines do. So if you do it the proper way, then you get potentially supportable positions and you get a feel for how likely they are to sustain a challenge. And that's how you do it. But the LLM's got a very basic issue here wrong. Why? Well, they didn't do that examination of the law. Had they only done that, and I will show you why I can say that with confidence, had they only done that, they would have gotten the right answer. Well, if they actually understood the structure of law, which is probably a little bit asking for them, but they don't. What happened was they prematurely went to other sources. And how they rated the importance of a source is not the way under the law you do it. Rather, they rated it like Google, a search engine, will do. So what happened was they started looking at this. So the OBBBA provisions regarding tips, overtime pay, and car loan interest were put in as deductions, added as section 63 which is a where do we claim these provision, right? That makes them below the line deductions. Already mentioned that, right? Now, and it doesn't reduce AGI. Now, we all know, right, in tax, without me having to go into lots of detail, that above the line deductions reduce adjusted gross income. That's why we call them above the line. Below the line deductions do not reduce adjusted gross income. We know that itemized deductions are a below the line deduction. But we also know that we get a few other things there, like we used to get, and we actually still do get, weirdly, exemptions, because we make the over 65 deduction, new deduction, that's considered an exemption. Weird, but that. By the way, the fact that that went through Section 151 was what actually allowed ChatGPT to catch this. I'm not sure why that became so, but they actually figured it out because it was a change to 151, and 151 was exemptions, and exemptions were below the line. That was the one that Chat actually caught and got right. The others all got it wrong. Gemini, Blue Jay, and Perplexity all put those above the line. All right, so ChatGPT did catch that. I have a feeling Blue Jay will catch it shortly too, because I think Blue Jay was trained on OpenAI's models that were used for ChatGPT 4, and we assume presumably will be updated to OpenAI's models that went into 5. And 5 did catch it, at least when it decided which method to really use. It caught it. By the way, what's more amusing about ChatGPT, which also found other things, well, it got some things right with 5, and it was easier to get it to fix and discover other issues. Including that weird one that I got with changing the question where it gave the wrong answer, but in the same response, it came back then and gave the right answer. When I actually went with ChatGPT and sent that back through with deep research turns on, it went back to the answers the other gave. Because here's the problem. It is that other information that's polluting their analysis. Now, there's a lot of documents have been written. Now, here's the first problem. The LLM noticed in their training, free One Big Beautiful Act training materials they had, that there was a very high correlation, very, very, very high correlation between deductions allowed if a taxpayer doesn't itemize and above the line deductions being referred to as that. And that such deductions were allowed in computing AGI. There was a high correlation. Now, it's not perfect because we did have 109 Cap A, and we had the non-itemizers deduction, and I believe we had a special rule for certain casualty losses a number of years ago that went in that weird category as well. So but it was like 99.9% of the time when somebody said it was deductible, even if you don't itemize, that was an above-the-line deduction that was used in computing AGI. Therefore, because Congress, when this law was being written, kept releasing information that said that these deductions were allowed, in computing, or these deductions were allowed even if you didn't itemize. You didn't have to itemize to get the benefit. That led to the LLMs inferring right away that these were above the line deductions, because I did have like this weird conversation with ChatGPT about why would an LLM get this wrong? And it very, very quickly said, well, based on training, Congress had traditionally always, Congress allowed items that were deductible to those that did not itemize were reduced AGI. That became their assumption. They saw each one of these referred to consistently multiple times as being allowed if you didn't itemize. That meant they decided they were above the line and they reduced AGI. So referred to them as above the line deductions and they reduced AGI. But, okay, so that was their initial belief, right? We'll call it a belief. It's not really, but that's the initial answer they came up with. They then used their web search to update, and they had already used it because they got in the stuff from the, what's in this bill, so they found this up. And so then they went out to the web. Now, this also is funny because a lot of human authors who were writing articles, especially right after the bill came out, to analyze these things, kept saying these were above the line. And so we see articles that I saw in places like CNBC. I saw them in some CPE materials. I saw them in at least one Big Four firm's commentary that somebody sent me. It's like, oh, well, that's not good. They all called them above the line deductions. Except they weren't. So it was a problem. So they had a lot of those that called them above the line, and a few even said you could deduct them in computing AGI. That reinforced, because, again, those get it out right away articles were normally done, and I can understand why. A lot of people would automatically make that connection in their head. The same inference the LLMs made, the people made. But those articles, which were wrong, have, basically poisoned the well. So it's not even more poisoned. Now, I do think that there's a reasonable chance, because we know the LLMs would have gotten to that answer, even if no articles were there, that I think a lot of the very early articles, yes, people used LLMs because you wanted to be out there right away with your discussion about what this bill is. Your audience, if you're a publisher, wants to see it discussed. If you're an accounting or law firm or a financial advisor, your clients want to know that you're up to speed and you've got this thing, you understand how it works. Turns out you may have shot yourself in the foot now, but you got those things up and running. So bottom line, they either, and I think what happened in a lot of cases was they didn't read the law, they were reading the discussions of the law. Again, don't ever interpret an interpretation. I've always said that, told anybody in tax research, if you're looking at interpretive materials, don't interpret interpretive materials. Make sure you go back. When you're analyzing a new law, make sure you analyze the law. Don't depend on others' analysis, because that can lead you astray. In this case, it's clearly leading not only the models astray, it's leading humans astray, right? So what we have now is a feedback loop. More and more of these articles, people either get their answer from reading an analysis, let's say, that was published on CNBC or whatever, CNBC, wherever. I believe it was CNBC. I saw the one. I got corrected, as I recall, but it was wrong to start with on this area, and other places. And then that means those people go and write blogs or post on social media. So the feedback loop becomes huge, and it's become huge, right? And it's become so bad, it's poisoning all kinds of weird things. It's like just weird how it goes. That feedback loop is a problem. That's why LLMs couldn't get it right. The problem was they didn't have the information to get the right answer. The problem was they had too much information, and they couldn't separate the important stuff, the controlling stuff, from the irrelevant stuff. the analysis of any of the big four firms, the largest law firm in the country, the analysis from Thomson Reuters, the analysis from, Wolters Kluwer's, that's irrelevant. It may be, and okay, it's not useful. It can be helpful, can be there. But remember, that's not the law. To quote the founder of the firm when I first started here, and he was talking to me about tax research, he said, I don't want to see references that come from anywhere that's not an agency or like the courts or things that are referenced in the U.S. Constitution and are allowed to speak to how this works. Right? CCH, as he told me at that point, we were a CCH shop, he said CCH is not mentioned in the U.S. Constitution. So the fact that CCH says this is the answer is not really relevant if you're doing tax research. Now, CCH's analysis may help you find the stuff that is relevant, and that's how you should use it. But that's not how LMs are working, right? They are looking at all of that, and because there's so much written about the law that's way larger than the law itself, they have decided to run with that stuff. Right? Well, just in the sense you call them deciding. That's really giving them credit for something they don't really do. But we do tend to speak of them that way, so we'll go down that path. Now, so what did I do? I used Notebook LM. If you're not sure what Notebook LM is, it's an AI. It is AI. It is a language model. Notebook LM stands for language model. But it's not a large language model. There's only one L there. What it's promoted mainly as a study guide, a study program, a thing to use for studying. But it can be used for lots of things, knowledge-based in some areas. You make the choice. I make the choice of what it's allowed to look at. Now, you can try to do that with a prompt, with some really, really heavy-duty, heavy-handed prompting with an LLM, but it's really difficult to make sure that you don't leave a hole that runs out and goes finds this other stuff. Okay? Notebook is looking at referencing the source. And it will tell you when it gives an answer where in the source it found what it's talking about. So it's not that it can't hallucinate. It's not that it can't have issues, but it's just way less likely. It's constrained. And for my purposes, one really big thing that became true here was the only thing I gave it was the tax provisions in the bill. The bill's tax provisions was all I gave it. I didn't even give it the existing code. That meant all it knew in this notebook was what was in the bill. I went through and I looked at each section. I then looked at how it would affect the code. But then I asked Notebook LM to summarize the section based only on what it knew, which was what was in the bill. And I made sure that I compared what it came back with what I knew, and I also knew that sometimes I had to fill in the blanks. Like for each one of these deductions, it referenced that it made a change and added a provision to section 63, I should say. It added to section 63B. Well, I knew that 63B was where you were going to find those things you could get if you itemized. If you didn't itemize, you'd still get these deductions. You'd get them if you did itemize. 63 is a weird one to read. And it does work. The 1040 does properly implement section 63. But it takes a lot of deciding how they get there. There's a lot of stuff you just got to recognize as how this is going to work. Because if you don't like the standard deduction per section 63, really itemization, et cetera, doesn't matter, which is weird the way it reads. So it just has taxable income computed. If you do itemize, though, if you don't itemize, then we do use AGI minus standard deduction minus these other things. So that's how it works both ways. You'll get it either way. Okay. Now, therefore, I knew it. I reviewed the sections. I did the summary. I did my own review. And by the way, what the summaries help me with, too, is every so often when I try to read these bills right up front, you get tired and you miss some obvious things. Nothing about Notebook LM, it doesn't get tired. Right. As you know, it will summarize the section. It doesn't know where the cross references go, but it will tell you they're there. And you then can use it, right? That helped me make sure I didn't miss anything. And Notebook LM had no clue about those decades of articles and that inherent mapping of deductible if you don't itemize with above the line. It knew nothing about any of that. So it never wandered down that path. It simply said, these sections add a provision to section 63. In addition to, having the deduction works like this, this, and this. And most of the detail of how things works is in the bill. But where they put it in the code is where you have to cross-reference out. And I knew Congress had previously introduced these below-the-line deductions in section 63. So I knew when I saw it was going to 63 how it likely worked, and I verified that it went to the right part of 63, and it worked the way that these be below the lines. These work like the QBI deduction. In the same manner exactly, right? So, posting inquiries to the LLMs about the place of these deductions in section 63, and noting that, as far as I could tell, it was the same as the QBI deduction, suddenly that woke up ChatGPT and woke up Notebook LM. Because then they started getting articles and information about QBI 199 Cap A, realized, hey, wait, this is allowed if you don't itemize, but it's not reducing AGI and it's not referred to as above the line. And that made it click. Gemini was a little more defensive about what it did. The real funny part was I finally got it to agree when I pointed out that not ChatGPT, but that Notebook LM, when I gave it just the bill, said this did modify 63. Because they would agree that if it modified 63, it would not be above the line. But then insisted they didn't because all those articles said they were above the line. Was literally what it was trying to defend at that point. And I said, well, here, I gave just the bill to Notebook LM and asked Notebook LM specifically about the tips deduction. Does it modify section 62 in any way? Does it modify section 63? And I gave it back Notebook LM's response. Now, I have a feeling somehow it recognized, it knows Notebook LM is its own thing. And it really is using Gemini's engine. So now it's like, that appeared to finally say, okay, maybe I better give up. And say, oh, okay, then, yeah, really. If it's right, it still was kind of hedging. But if it's right, it modified 63, then yes, my analysis would be wrong. This is why LLMs can't really be used and that's also why you can't just take somebody with no tax research experience and have them use an LLM and get an answer that will be reliable. Because they go off the wrong way. They're just not doing it right. They're doing it wrong. Like the old iPhone that you would kill the signal on if you held it a certain way, you're holding it wrong. They're doing it wrong. That's the problem. And it's kind of the nature of LLMs that they would do it wrong. So how do you leverage them? Look, they have immense data. They can uncover things you'll never think of. They are great for finding stuff. They are great for uncovering things. Like I just had to deal with an issue involving a potential charitable contribution. They didn't want to make it this year, but they wanted to lock in the stock price. And so there's all these things. And I said, I kind of remembered the Estee Lauder background, right? So I remember Estee Lauder. Can you give me at least that background? I want to be able to give them the background of the Estee Lauder case. Now we got section 1259 and how that really complicates trying to do what they're wanting to do. Yeah, LM was great. It even noticed that, I said I thought it was a tax court case from the 90s. No, it wasn't. Never was a tax court issue. But yeah, it had the whole event, did all that. It's great. It uncovers that stuff. It can do that. LMs are great at relatively well-settled areas of the tax law. They can produce very good discussions. I will use them regularly to try to translate to plain English. I already know the answer, but I can use them to give me something that will be easier to understand. And I can use, kind of just like when I'm trying to put together like a 1 or 2 hour course, I will definitely use it to get the basic outlines together. especially when it's an area that's really evergreen. Where basically, we're going to talk about basic treatment of, based on, like recently, how do you blow an S election? Well, that's really hasn't changed very much in recent years. Okay, it's good at that sort of stuff, where it can go out and where I know it's going to find a sea of very competent articles. Now, I do prompt by specifically limiting it. I say, please provide, in support of positions taken, references to primary source materials, and I list what those are: IRC code sections, case law, regulations, etc. Now, even if you're a person that doesn't like to read that stuff, you're going to find that by asking it to get primary references, you're going to get much better articles it will rely upon, and you're going to find that when you get to a section of whatever you're reading and you don't see any primary references, that's a really big sign, or you just see one and no footnote reference, that you may be in hallucination mode at this point, right? It's creating it out of fair, because it can't cross-reference to anything, right? And that's kind of the problems. You have to know how to use them. If you don't learn how to use LLMs in your tax research, you are going to be, at best, wildly inefficient. And you're probably going to miss a lot of things, because LLMs, because they look broadly and find all this stuff, more stuff than you could possibly look at, that deal with the issue you're looking for, they can uncover stuff you never would have realized were there in an instant. So they're incredibly useful, but they are absolutely not the end of the search. You have to realize that, right? They will not render professionals obsolete, because I happen to believe our problem is very simple. While, the former Google executive I referenced at the start of this section, while he will know way more about AI than I will ever understand, I have no doubt about that. But he doesn't actually know how all of these other areas work. He has an overly simplistic view that believes memorization is all you need. It's not. As I hopefully have pointed out to you now, the fact that it knew so much was why the LLMs all got the answer wrong. And the fact that Notebook LM only knew basically the bill is why it got the answer right. But that involved judgment to realize, what do I need to feed Notebook LM? And I only wanted Notebook LM to help me analyze the bill, because I knew the bill was where I was going to find every answer, or at least find my way to get to every answer. So that's it. So anyway, LLMs. If you hung around this far and didn't stop after the updates, this has been this week's Current Federal Tax Developments for August 25th. Look forward to seeing you guys next week. We'll talk about whatever goes on in the coming weeks. We are getting closer and closer to that first drop dead deadline of September 15th. Then like every 2 weeks, we got a new one coming up. So remember those. Start looking at your S Corps and partnerships, and bugging the clients haven't gotten you everything yet. Get that part going. Again, I do write messages and respond to things on the Connect sites for Arizona, New Jersey, Idaho, and Minnesota. Also look in on Washington. So if you remember one of those states and you got something to talk about, you got a question or something, and you can find the right place inside there to post. You can post. If I see it, I'll try to respond. Otherwise, though, you can email me at zollars@currentfederaltaxdevelopments.com if you have some issues. But otherwise, I will see you guys next week for more current federal tax developments.